I do. You go. Okay, well, a minute early, but it looks like all parties of interest are here. There it is, 4 o'clock. I'll call to order this meeting of the, Ordinance, Public Relations, Newsletter and Webpage Committee of the Ojai Valley Sanitary District for 2026. Any public comment, Allison?
We have a submitted public comment, but for item 3 on the agenda, not under item 2.
Any public comment about items not on the agenda? Okay. On item 3, review and discussion, ordinance OVSD 82, district accessory dwelling unit ordinance.
Can I ask a procedural question before we?
We're
We're going to discuss this item at the full board meeting. And we're going to discuss it during closed session, I believe. True?
That's the one we're here for. This is accessory dwelling.
Yeah.
Okay, so the closed session item doesn't have to do with ADUs then.
All of
Okay, so we're gonna take care of this issue. The ordinance committee, not carry it to the board, full board.
No, we will bring it back to the full board, but in open session.
Okay. Okay, I think I have it. Thank you.
Okay. Go ahead, Scott.
I'm gonna let Dennis proceed.
Up, I mean, so, the reason we're here today is to discuss OVSD 82 and specifically, the imposition of capacity charges in a certain scenario. Now, know when there's a attached ADU, we're not or to impose capacity charges. The situation we're dealing with is a standalone ADU, which is one that's not built within the existing space of a dwelling unit or an accessory structure. And so the question that's arisen is, under the statute, we can require a standalone ADU to connect directly to the main line. However, that very seldom happens. And the statute's pretty clear that we can impose capacity charges in that situation. But the question is, when connection goes through a private lateral line, there's some ambiguity in the statute we've discussed before as to whether district can impose connection fees or capacity charges. At one point, I was tasked with contacting HCD about this. They were aware of this nebulous issue with the statute. They weren't prepared to take any position. I spoke with Jamie Candelaria over there. He's the head of that department. She indicated they hadn't taken a firm position on it, and aware of this coming up. So in response to that, the board decided to take no action, stand pat until they got some sort of more clear direction from courts or the legislature or have you. It was 3 or 4 weeks, maybe even longer than that. Out of the blue, I got a follow-up email from Candelaria at HCD. And she said, well, we've had more inquiries, more instances where this issue's come up. Looked into it further. How we take the position that the statute requires that we do not impose capacity charges when there's a tie-in to existing private lateral, only if there's a new direct connection position. Now, she said this to me in just an informal email. I haven't received any, technical assistance letter or formal direction. We haven't got any notice that our ordinance is not in compliance from HCD. be that as it may, she was pretty clear in her email that that's her position and she says the position of HCD. So reported that to the board. We decided, well, we better again in a committee meeting, and here we are. So
Would you like to ask questions?
I think
We'll have time for public comment on each agenda item as it comes up. The first thing we do is get a report from staff on the item. If we have questions of staff, we'll ask those, clarify the issue, and we'll have public comment.
and public comment again would be an opportunity for the public to speak. I think our time limits are generally minutes or so. They can present their concerns to the board.
Well, gentlemen, any questions of us or Scott?
Yes, go ahead. We've been to court on this issue, and it seems to me that there was a provision in the law that said there was a time limit for protesting. Does that apply at all to us today?
Yeah, there were time limits for protesting our ordinance. I'll also say that HCD approved our ordinance. So we revised the ordinance OVSD 82 because it was not in compliance. That we were illegally charging capacity fees for attached units. Given the statutes, we had to change that. We changed that in our ordinance, submitted to HCD for their blessing. So they gave us. So they've approved OVSD 2. We haven't received any official notice of violation or anything else, you know. And again, they are not a binding authority necessarily.
Yeah, could you describe HCD and what their role is in the
So
process?
HCD can provide their
Is it a state agency? or-
state agency. They can provide their interpretation, their guidance to agencies. If they feel that an agency's ordinance is not in compliance, they can issue a series of letters ending with up into a notice of violation. So they would call a violation of the statutes, and they would refer that to the Attorney General. The Attorney General's office would then be in their lap to see if they wanted to carry that ball and run with it. None of that has happened. In fact, I haven't even received any, real formal direction from HCD other than email that's in your packet from Ms. Candelaria.
Could you describe the 180, I think it was 180-day limit for folks to object to our ordinance?
Yeah, there are time limits for people to object to the ordinance. However, if there is a discrepancy with state law, it'd be corrected.
To be corrected, that's what I'm looking at. Well,
Dennis, you mentioned that they had approved, we revised that ordinance in 2021, I believe. Early 2020, first half of 2021. So we approved it within the board, it got published, all that. When did HCD actually give us a notice or a letter or something that said they felt we were in compliance with the rules at the time? You know what, it would have been that same year.
It would have been then before we published it and made it official. We ran it by HCD for their blessing.
Okay, so let's just say that was sometime in 2020. So every year, the legislature, revises rules and regulations and things get renumbered. And so one of the questions around this particular rule that's being quoted that we're not supposed to be able to do that, as far as I know, that language has been at least in 2 versions of the state.
That language has remained the same. The ordinances have been renumbered a couple of times, which adds to confusion on top of all of this. And
The references in state.
references, but the language itself has remain changed
since
we adopted the 82.
so that language was in place in 2020.
In fact, we did get a technical assistance letter from HCD. It was addressing proportional charges, not this issue,
This particular issue.
how a lateral is plumbed.
So
And our ordinance doesn't distinguish between how a lateral is plumbed, and the statute itself is rather vague on that. It doesn't refer to the sewer laterals. It just refers to, it does refer to new direct connections. But we may require new direct connections. It goes on to say the connection. That's kind of where the ambiguity arises. Is the connection only a direct connection or any connection associated with the ADU?
The government code is currently silent on the issue of an ADU connection that goes to a private lateral rather than to the main line. There's no word.
it's not explicit, but to me, it's very clearly implied. Given what the director of that group just said, that's their interpretation of it too.
That seems to be their interpretation now, 6 years later.
I don't know what their interpretation was back then,
My interpretation,
but the language hasn't changed.
my interpretation aligns with Steve's. Wording allows us to, the wording of the law allows us to charge connection fee for a connection. Otherwise, people are getting free treatment. You can add 5 ADUs to your house and you get free treatment. I've thought about this long and hard over the last couple of weeks, and I realized that it really doesn't matter what my opinion is. It matters what a judge would believe. That's why I need to ask at some point in the discussion today, if we talk about what the legal risks are for, we have no closed session today, so we'll have to do it on the open, but what the legal risks are and what you recommend.
Yeah. So the legal risks are if HCD wanted to move this along, there would probably, in all likelihood, be some steps that they would first give us a more formal letter or technical assistance letter or recommendation saying the ordinance or the way you operate under your ordinance is not in compliance. Next level would be, we're finding that it's not in compliance and you're within 30, 60 days, something like that. If we did nothing in response to that, they may then refer to the Attorney General's office. That doesn't mean the Attorney General's office would necessarily follow through with it, but could. And if they did, they might file a lawsuit. I would anticipate that they would contact us before they did that and attempt to get our voluntary compliance with their interpretation. If the Attorney General's office did file a lawsuit, then it goes before, a judge in a court of law, and he or she would make the interpretation. So
That's if there's a lawsuit from the Attorney General.
right.
And the general public and our customers sue for this
I
time.
think they're time barred at this point.
Their time.
Yes.
I'm sorry, what was that?
Statute of limitations is run on challenging this statute. Mr. Bain is,
Some new ADU owner could, always because it's the ordinance, it's not the ADU
Yeah.
application. That's the time.
Is that right? The date of the ordinance, regardless of what happened
right.
in between. Because that's the issue for me. It's clear from what, can't pronounce her name, what she just wrote to me, even though it's somewhat informal, is that we are not and should not be charging for those types of connections where it's right from a new ADU into an existing private lateral. So
I will say
if
it's a
that's
little,
true, then the question becomes, okay, so we can't do it. What about retroactive? How do we deal with the fact that we have been charging that for now several years apparently? How do we, how does HCD address that retroactively issue, the retroactive?
and I will make one more caveat here. You know, some of this should probably go into closed session when we get it really into the issues, but our ordinance doesn't really distinguish between private lateral connections and direct connections either. So it may not be invalid. Its face, it just may be the way we're applying it. So,
Not explicit. Yeah.
The ordinance is not explicit. And the government code only speaks to one of the two situations, silent on the other.
Disagree with that. I think it describes one explicitly and says if it doesn't match that, then this, which is the words that were, she quoted in her letters, was it goes, it's not that one, which is a brand new lateral directly from the ADU to our system, or it's a new lateral that we required somebody to put from the ADU to our system. And that's, if it's not one of those, then it's this and that, you know, to me, the language has always been very clear ever since this came up. But
Scott?
That the second if statement that you cited is not there. That second if statement is missing.
I have another question, Dennis. Let's just say hypothetically that a year from now, HCD comes out with a new interpretation. Say, well, you should only charge half as much, 0. Not the full, whatever it might be. At what point do we decide the date on which we change everything that we do? And is there a retroactive aspect to an HCD opinion?
Again, the HCD opinion, it's not just because they've issued an opinion, that doesn't mean we are bound by it necessarily until it's been tested up the ladder, so to speak. However, if we clarified our ordinance, you know, to exclude these private lateral connections from charging. Yeah, I mean, we have an issue there because we've charged a lot of people for those, and I believe Scott can speak to this, that 90+% of the connections are to private laterals for these separate ADUs, right? We don't make them go out in the street and connect directly because it doesn't make sense.
Correct. I know what I've done. Since I've been here, there's been about 80 ADUs permitted. One of them was a connection from the ADU into the main line. That one that was permitted was a rare circumstance in that the main sewer line was in an easement in their property. It was a very, very large property in Rancho Matilaha, and the ADU was a far distance back from the main house. And they requested it to make a main tie into the main line, frankly, because it was easier and they didn't have to tear up a bunch of landscape, and it was more feasible. So if you're looking for a percentage, it's about 1 in 80 based off of what I've seen.
And the other 79
Yeah,
went into a private lateral.
correct. The other 79 went into a private lateral. That's right.
and we charge for all of those.
Yes.
So Dennis, could you speak to the requirement, if there's any legal requirement? We change our ordinance, do we have to retroactively reimburse people for their?
I would have to do a deeper dive into how far back and when we would have to reimburse for those prior ones. But
It's sounding to me like we have 80 or so ADUs, roughly $8,000 each.
If you're looking,
$500,000.
if you're looking, yeah, it's more than that. If you're looking back to 2020, I think it's over $1 million. It's $1,016,000.
And is that chart?
Yes.
Say,
So that chart that I sent, the bar graph that I sent includes sewer service fees and inspection fees, but I was able to dive through it, and I had a second table that I sent out earlier this afternoon. And it was just the sewer capacity charges.
which is on this chart, which line is that? Just that,
It's not on that. It's not on the chart. It was on a separate email that I emailed.
I don't-
It went out at 12:42.
okay, so the point is from 2020, there's been 80. We think that the capacity charges we've charged for those 80 or 79, there's capacity charges for those we think are somewhere around $1 million to this district.
There's been about 80 ADUs since I've been here in
Since you've
2 years. Since I've been here, since we've done the ADUs, we're looking at 279. And of those 279, my rough estimate would be 1/80th of that 279. So 4 or 5 would be direct connection, and the remaining 274-ish would be reimbursed.
Now, as far as reimbursement, if and when we should do that, I would guess the majority of those 270 some odd chose a 5-year plan rather than just a one-time payment. So the total number you're quoting might be somewhat reduced because they're still got years to go on their payment plan. Is that true?
Statistically, not really that true. I would say probably we approve about 10 a year, and not all of them are necessarily for ADUs. So you figure over a 5-year span, I mean, maybe, but not a considerable amount to reduce that number by any significant amount.
Okay, so when you say we approve 10 a year, that's 10 5-year plans a year?
Correct, that aren't necessarily only ADUs.
Okay, because that didn't match the 270. Okay. Go ahead.
I thought it may be important to go back a little bit and look at the California Government Code 66323 and note that the intent of that code addresses both water and wastewater. So it's water and sewer. And in doing so, it may give us a little bit of a different perspective when we're talking about new connections, separate connections, and existing connections. Because there is somewhat of a fundamental difference between water and sewers in that on a water system, oftentimes the meter is the limiting factor. And the meter is what constitutes the capacity charge that the utility eventually receives. And I'm happy to give a couple examples if it would please anyone to kind of see how things may be slightly.
Load on the water system is measurable.
The load on the water system is measurable, and it's measurable by the diameter, the size of the meter. Right. And so and as an example, say you had a 1950s house that was a modest 2-bedroom, 1-bath house, you would have had a 1/2-inch water meter. If you wanted to put a modern ADU, a 2-bedroom, 2-bath ADU onto that with washers and dryers, the building department is not going to let you tap into that 1/2-inch water meter. The building department is going to tell you, listen, you need to go, you got 2 choices. One, you either go out to the main line and tap in with a new meter that goes to the ADU, or you upsize your plumbing and your water meter to such a size that it's capable of providing the necessary flow for your existing house plus the ADU. Where I'm going with that is whether it's the existing that gets upsized, the new, the existing, which is off the books, the new, which would be the upsize, or the new separate, the water utility company is going to be getting their capacity charges. Whether you pay for a new meter that connects to the main line, or whether you upsize the existing 1/2-inch, you're going to be paying that capacity charge. We are similar in that regard. The only difference is you don't really necessarily see the limiting factor right in our 4-inch sewer lateral. Private sewer lateral may not be the limiting factor, right? The limiting factor is somewhere between the local line, the trunk line, and the treatment plant. Or what is the limiting factor of our utility? Where is our cost, and how do we mitigate the extra flow from the extra cost for the extra flow? My point is if you look at it from a water perspective, and it is very clear that the code is written for both water and sewer. We're looking at it from our perspective only, which is sewer, but the code was written to try to address both.
What does the code say about connection fees?
So the code says that a connection fee may be required, or that the water corporation, special district, or local agency may require a new or separate utility connection directly between the accessory dwelling unit and utility.
That sounds like the ADU one.
Yeah.
That's exactly what, but my point is if you were to tie in an ADU to an old house, the building department is going to tell you whether you can or cannot use your existing water meter based off of the fixture unit counts. And if you have two mitigation possibilities. One is you upsize your water meter, or two, you run a separate water meter out to the main line for the ADU. Whichever way you do it, the utility is going to be compensated for that extra capacity.
Well, you're thinking, put aside this ADU law, you're saying that the existing California law for connection fees allows us to the connection fee for a standalone ADU?
That's not what
Only
it
if we require a new, then we can. That's what Scott's saying.
I'm
If they require a larger
I'm-
meter, then you can charge for it.
or
We've never yet told anybody your sewer system isn't big enough to handle the ADU.
but we have penciled it out at the 25 drainage fixture units per single family dwelling. That is how we have done the math for our system.
In no case have we ever said your existing lateral will not handle the additional required capacity. Which is different than the case you were describing for the water. It may require you to add a larger meter to handle that, and so then they would charge. And if we should require one, we can also charge, but we've never required one. We've never required an upsize or a new direct connection.
And we're talking strictly about capacity charges, not
Right.
monthly service charges.
So I see the relevance of bringing up the water, but we've never entered that situation.
Well,
In our
true, but nor would a water utility that had a house that was built in the 1990s that was fitted with a 3/4 inch water meter that was already oversized. That also wouldn't require. So I guess my point is one way or another, the water utility company, based on drainage fixture units counts, is covering their necessity and their proportional costs where it's necessary.
So to me, all along, it's been clear that we shouldn't be charging for this ever since it came up. So I know it's just my opinion, but it's my opinion. And so the question then comes about retroactive. It seems to me, there's some reliance that we could place on the 2020 determination that our ordinance was in compliance. Only June 6th of this year did we learn that our ordinance was not in compliance. And somewhere between 2020 and now, if there were to be a retroactive reimbursement, it would be within that timeline, time space. And so with that in mind, it would seem prudent for Dennis to go through ordinance, the state, not our ordinance, but the state rules around this from 2020 when we finalized ours to current, and just make sure that there's been no change in language that would affect how we might view a retroactive payment. We know that the numbers have changed, but the language has not, at least for the past 3 years that I know of. But I don't know if it did before that. I don't know what the language was in January of 2020, for instance, at the time that we started in our deliberations around changing our ordinance to match the bigger issue of whether we could charge for an ADU at all, which we We couldn't, so.
When this ordinance 82, there were two aspects to it. One was the capacity charge. And the other was a proportional capacity charge
Right.
factor. I remember because this was 2021 and I was sitting in that chair at the time. But we decided then that there was some retroactivity there. And because at the time, the district was charging regular single-family dwelling capacity charge to an ADU regardless of its size. So we decided, and I cannot remember exactly the basis on which we decided to do retroactive payments of those proportional charges. Was some ways back, I think a year more than Mr. Kwong wanted. But it was not 5 years, it was not 10
I
years.
remember it being 2 or 3 is what we did, but I don't
Something
know
like
why we chose that.
And I can't remember how we determined that. But it had to do, I believe, with the date at which we were formally notified that we were out of compliance with the lack of proportional charges. So we
My
went back
memory
to
was
when
it-
we were notified that proportional charges should be imposed. I think from there forward,
No, so we were formally notified with a letter of technical assistance in 2020. We retroactively, as a board, the retroactive reimbursements went back to 2016, which, to what I remember was actually to the inception of ADU legislation.
That's right.
In its most minimal sense, in which it was most definitely not clear, to the extent that this agency actually had a moratorium on ADU approvals and charging through 2019 because of the ambiguity or lack of addressing any charging of capacity charges at all. So it was so unclear. And then it was not until, and Dennis may remember this, I believe it was the 2019 update, what was 65852.2 and 0.22, that it became clear enough to reasonably analyze the letter of technical assistance to realize that, yes, the district should in fact had been charging proportional. I believe the letter of technical assistance even addressed that by recommendation of DFUs and or square footage. And it was determined that square footage is actually not a permissible way to determine proportionality as it pertains to sewer. And so that's what my recollection was.
Mine matches yours, that it was tied to, because we weren't notified of compliance. There was threat of a suit from 1 or 2 agencies, and that didn't happen until 2020 or 2021.
Yeah,
Because I had just come to the board, and that was the first thing we had started to address. My recollection was that we went back to the inception of the rules or whatever and tied it to that rather than to our specific note, which is the same problem we have now. The question is, at that time, did we or the CD not recognize that there was that issue within the, and it may be because we know that other districts have been charging for this very type of thing. Others have not. And so, as she mentioned, there's been confusion around this, and I'm glad they've finally taken a position on it. Because I think every board that's been charging in the manner we have is going to have to go back and deal with the same problem we're facing. And in this case, I didn't realize it was such a big number. That's potentially well over $1 million.
Dennis, what year, was it January of 2025 or 2026 that it was recodified? Because I don't think there were any changes up until then.
There was actually 2 codifications and it didn't change either time.
Because I don't think there were any renditions after 2020 or 2019, and then except for the one that was recodified and somewhat condensed, but I don't think there was
My
anything.
recollection is the current version has been the same since 2019,
I think
Current language.
language.
Yeah. Even so, we were told that our this was in compliance. We now know, or the opinions now that it is not, so. But that's the quandary we're gonna face. If we're gonna change it, which I think we have to now, but what are we gonna do about the retroactive issue? And that's, to me, a very difficult decision.
And if it changes again, then what do we do?
The rules are gonna, they could change every year. Every January, the rules could be completely different.
And how,
So that doesn't,
how retroactive do we make each new interpretation?
until the date of the,
That's,
I would, to me, if there's a rule that says this, and it says that for this length of time, and then it says something different, meanwhile, you find out you're out of compliance, you go back to when did the rule change, which is what we did in 2019. So if the rules change, then we retroactive to when the rule changed. The problem I see is, you know, I thought originally that this was a case of the rules having changed since we issued the ordinance. In which case it would have been incumbent upon the board to recognize the rules had changed and do something about our ordinance.
agreed.
But it turns out the rules never changed.
What changed was the state's interpretation of the law.
This person
State
said that,
agent.
but I don't know what they
The
said.
state agency's interpretation of the law.
According to the email that I received, which is again, a rather informal way of notifying an agency, I would say.
I,
That's not to say that a more formal opinion is not in the pipeline here.
might not be comfortable. So
I think we've probably clarified this as much as we can with staff at the moment.
Actually, I have one more question.
Okay, great.
That would be allowed. I have kind of a philosophical question that has arisen as I was reading the background materials. We are bound by the requirements of Prop 218, which is basically, I understand, part of the California Constitution now. Prop 218 is very clear that the rates we charge our customers have to reflect the cost of providing actual service. The problem that we have with this particular fee is that some of our customers who do not have ADUs are going to end up subsidizing the folks who have installed ADUs and connected to their existing lateral. So we have one class of customers that is going to be subsidizing another class of customers. Would it be worth writing a letter to the HCD and pointing this out and seeing if they have any response?
can I comment on that?
Sure.
We treat hundreds of our customers differently than others. We learned that the other
How
day.
so?
We learned that the other day when the people came in talking about their trailer homes, why they should be charged the same as a house, which has more people.
Or they should be charged differently because they're older.
Yeah, and so, you know, we have,
We don't. We treat them all the same.
and that's the problem. Some are subsidizing others, which is his argument. Because a person that has a trailer house doesn't have as much flow or need, whatever you want to call it, as a person with a 6-bedroom house with 4 kids. So we treat people differently now in terms of subsidizing each other or not. We treat them universally the same without regard to what their true usage is. And so his argument or his question is, you know, if we're subsidizing one and not the other, we're already doing that. And so, but I don't know if that didn't help clear the
There's
question,
no-
but I just don't see how, the reason we can't do anything about it is because what Scott was saying, we don't have a meter. We don't have any way to measure actual use.
But there is some.
The flow remains the same, whether it's attached to a private sewer lateral or if there's a direct connection to the main line. The amount of effluent burdening the system is going to be the same. So that
Because there's more people now living on the property. ADU presumably.
No, I'm saying.
He's saying the load on the
Whether
system.
the ADU
doesn't
attaches directly to the
depend on the
main line or ties into the
Oh, that's
existing
true.
house, the amount of effluent is the same.
That's true.
Do you have any thoughts on philosophical questions?
Yeah, so Proposition 218 says, you know, if we increase sewer rates, that the rate cannot exceed the reasonable cost of providing that service. It doesn't necessarily say that it's less than that. It's more concerned about not exceeding the cost. But from an equitable and fairness point, I get your point.
Okay. Let's hear from the public then. Who wants to speak?
We all want
I do.
to. I do too, but what do I? Right.
Hi.
If you would, come up, give us your name and where you live, and
Can I do that on the mic?
there's a.
Or you can sit there if you're more comfortable.
I'm gonna stay here. Hi, my name's Christy Price. I built an ADU in Oakview a couple of years ago. It's 559 square feet, detached, 1 bedroom, 1 bathroom, washing machine, standard. My existing home is less than 1,000 square feet with 1 bathroom. OVSD charged me $9,000 to tie into my existing sewer lateral. OVSD never required a new connection to the sewer main, so should not be able to charge these capacity and connection fees. And I know this, it's very clear to me in the government code that I've pored over many a times. I'm gonna reference some old numbers because those are the numbers at the time, and this is my old documentation. But government code section 65852.2 states that connection and capacity fees can be charged only if a new separate connection between the ADU and the sewer main is required. And that new and separate connection may be subject to connection fees or capacity charges. If that's not clear, Government Code 6603, subsection B, part 5, provides a definition of fee. It says that a fee is for the physical facilities necessary to make the sewer connection, including the pipelines from the structure to the from the ADU to the sewer main, and the estimated reasonable cost of labor and materials for installation of those facilities. When we put in our ADU, the water district here, BRWD, required us to put in a new separate connection. They gave us 3 separate quotes from companies, the excavation and the hot tap to that system. I got the bill after the work was done. It was inspected. Permits were pulled from the county. The work was done according to the state law. So if those 2 things aren't clear, the Housing and Community Development ADU Handbook describes how sewer districts shall not consider ADUs as new residential use for purpose of calculating connection fees and capacity charges. Furthermore, the HCD provided that technical assistance letter in November of 2020, and it addresses ADUs for which a connection or capacity fee may be charged. That is their question. It says a new utility connection directly between the ADU and the utility. If such a connection is mandated, then a fee or charges may be imposed. Pretty clear. Still, OVSD was out of compliance. If there is no direct connection between the ADU and the sewer main, OVSD cannot charge connection fees or capacity charges. Sorry, I just need to take a breath and water would have been good. The ADU, the HCD ADU handbook also talks about how fees shall be proportionate to the burden of the proposed ADU to the main house compared to the primary dwelling, not proportionate to the average DFUs of new residential construction. According to OVSD regulations, 1 capacity unit equals the average wastewater flow generated by 25 DFU. Using the DFU approach, our primary dwelling plus the ADU are only at 22 DFU. Therefore, our entire property is less than 1 capacity unit and should not be charged fees and other capacity charges. Yet we were. Also, OVSD regulations describe that service fees are derived from service units, which is a measure of sewer service provided to a parcel. This parcel has less than the average 25 DFU, so we are already paying our fair share. You had a good point about the monies, someone brought it up, it was you, about the monies that have been paid. Most people, or several people, did a deferred agreement. I did $9,000, of which I paid $1,000 upfront to get my will serve letter. That money, I believe, goes into a reserve account. According to state law, there's a separate account that is required for that money. So it should not have already been spent on other things, as far as I understand. It should be sitting in an account. That's all I have to say.
Have you presented that to us in writing?
I have, yeah, about 3 years ago. I stood here and spoke to the board,
Some of those references,
and then I went to court.
those references that you cited are new to me. I don't remember reading those, so maybe you could, if you could find her letter.
The references are actually from the old version of ADU legislation. Since 5852.2 has been recodified.
This is not new interpretation. This has always been their stance. Back in 2020, this was their stance. OVSD chose not to change their ordinance. And by state law, if you are not in compliance with state law, your ordinance is null and void. You cannot charge fees.
Thank you.
I'm excited for a refund.
Anyone else wish to speak?
Follow that.
Yeah, I'm trying to think of it myself.
Not follow that. I mean,
I'm not as prepared as Kristen.
yeah, no.
Oh, I've been preparing this for
I know.
years.
So we just, I'm Jeff Goodman. We just are completing a tiny house on the back of my property. I live on Grand Avenue right downtown. The city is encouraging tiny houses. So I was really surprised. We got a bill for about $8,700, I think. We had to pay $1,500. This is just a few weeks ago. We don't have our final sign off yet. So we had to pay about $1,500 upfront, and now we're on a 5-year deferred plan. I totally get that, we're contributing. If we have more people on the property, we're contributing to the sewage. I get that, and I think it's fair that we pay a little bit more. But $9,000 seemed a little bit excessive, and it scares people. And when I tell people, when they say you're doing this, how much did it cost? I said, well, right up front, we had to pay all these fees, $9,000 to the sewer. And we didn't even know that when we started building. We couldn't know it until we were like halfway or 3/4 of the way through. Not that we would have stopped building, but the point is we should know what the fees are, or anybody should know what the building fees are, within a certain range. But $9,000 is not, if it was $200, nobody's going to complain. But $9,000 actually affects the total cost of building. So it could definitely make people think twice about adding another unit, which is the whole point of what we're talking about at least in the city of Ojai and probably in the valley, that we need more affordable housing, or at least more housing. This is not going to be nobody can build an ADU cheap. Okay, so I wouldn't say it's affordable, but it's more affordable than buying a house. So, I can't really add much. You've done your homework, but it seems to me that if there's a gray area, you should be erring on the side of not charging people, not charging and then worrying about later what you're going to do. So that's all I have to say.
We built 2 ADUs, the original homes on.
Two tiny houses.
2 tiny houses. The original size of the home on one of them is only 100 square feet. And the
300
Oh.
of the house.
The house is 800 square feet, and the tiny house is 400 square feet. Well, it's only 1,200 square feet of living space on the entire property that we paid over $9,000 to hook into our own sewer that's already lateral. Across the street, we did another one with houses like 700 square feet. Square foot tiny house, so that's still a total. It's like a lot of people can't live there. It's only 1,000 square feet. And we also tied in laterally, and I think it was like 8,500 or something. Again, like he said, these were costs that we didn't know were gonna be incurred until we were halfway through the project. And, you know, I just feel like there's a lot of invasiveness with costs and it's so high. Why is it so high? You're only adding like a couple hundred square feet and maybe one body. I mean, how much are they actually using? It's not like we're building a whole nother house. Our house is her house, my house and his house are all still smaller than a Rancho Matilha house. All, if you put all our houses together.
Like doing an addition.
Exactly. So, I mean, that's all I have to say is like, we're still at 1,200 and 1,000 square feet total living space on both properties that we added the tiny house, and that's with the tiny house.
I have a question for you, sorry. Do you have to pay an additional monthly fee for each one of the houses as well?
Not that I'm aware of yet.
It's on your tax roll?
Oh, probably. on my
Haven't got it
tax-
yet. We did them both in the year.
There are monthly service charges
Sure there is.
go on the tax roll.
I mean,
It's against the law too.
we're still under the size of a mobile home, like with the property that we
So
have.
what I wanted to say about it is, and the whole reason why we're doing it is we have two of our kids that live here in Ojai. Right? So we want our kids to live here. We have 6 kids and we wanted 2 of our kids to live here in Ojai. So they live in the smaller houses. So we built 2 tiny homes, 300 square feet and 400 square feet, each of them. So our kids can stay here and live here in
You
Ojai.
must be outside the city.
I'm
No,
down,
not
I'm
the city
on
limits.
Fox Street, sir. I'm downtown,
We're right on the way to the athletic club,
right on the way to the
in
athletic.
the city limits.
We built those tiny houses so our kids can stay here and live here, but the incurring fees that we're getting from all of this are pushed all of our kids out of Ojai. And that's,
They're born and raised here and they.
I
can't
was
even
born
afford
and
to
raised
live,
here, sir.
Which is a whole nother topic.
And I want my kids to stay here. And I can't afford to have my kids stay here when I'm paying $10,000 twice, or $9,000 or $8,000 twice, on top of what I'm already gonna pay you guys.
Why did you ask about if we were
Did
city
Did
limits?
your contractors ever say anything to you about fees?
They did, but nothing about sewage fees. There was nothing in the documentation in any of the contracts that talked about have sanitary district and paying, you know, almost $10,000 in fees.
They mentioned that you're gonna have to hook up to the sewer.
Yeah, we're gonna have to pay a fee.
But they didn't say how much.
Didn't say it was gonna be as much as
It
it
probably
was.
just meant for the plumbing.
So,
Yeah,
and ending
exactly.
here with what I have to say, I'm trying to support all of you people with your kids and your grandkids to stay here in Ojai. That's what we're trying to do here. We're not trying to build it so we can make a lot of money. I don't really care about the money. I have money. That's not the problem. Problem is, I want my kids to stay here, be able to live here, be raised here like I was. And now you guys are incurring fees and all these different things that are pushing people out of Ojai. You may think $9,000 is nothing, but when you gotta pay it twice, it's a lot of money. That's your kids and all of your kids are gonna be pushed out of Ojai.
You were charged for each one?
Yes.
$9,000 for each?
Yes, thank you. And what upsets me about it is when you talk about it, everybody just wants to push it into the corner. And I'm bringing it up front because I know this gentleman over here, his daughter went to school with mine. You know what? My kids have to move to states of North Carolina, New Jersey, Tennessee, and the 2 that want to stay here, I'm trying to help them by building a unit so that they can afford to stay here. My property taxes are probably as much as all of yours, unless you're on Proposition 13 or whatever you got, or whatever it was. But I pay $10,000 in taxes on each of my 2 houses downtown Ojai, $10,000. So I'm just trying to bring it to your point that we're trying to keep people here in Ojai. We're not trying to build things that are going to make us a lot of money. We're trying to keep our local people here in Ojai. I was born here, raised here, went to Nordoff, went through the whole thing, tried to keep my kids here. 4 of them cannot afford to live here. So that's what I'm trying to bring to the board. These extra fees and all these fees that are costing us are adding to people not putting in a tiny home or not putting in an ADU. Once they see these recurring fees, they're like, hey, wait a minute, that's too much for me. I'm not gonna do it. We need more homes here. We've all talked about it. People have had meetings. We need more homes. We want to get accessible homes for more people. That's what we're trying to do here. That's why we're local people. I mean, my wife and I,
Yeah,
at least,
even the tiny house that we put on the one property that's rented is rented to my son's mother-in-law because she can't afford to stay here either. Like, so, I mean, I'm not trying to say, hell, we're good Samaritans, give us a break. I'm just saying like, it's unfair and apparently it's unlawful. It's outside of the statute. It's just like, I mean, it's $18,000. And he paid one in full and the one of them payment plan, so it'll cover taxes.
Thank you.
yes, thank you. Thank you for listening.
Can I get your name for the record?
Elsie Rice.
One more thing I want to say. So it would be nice to get a reimbursement, but in the meantime, we're paying, it's adding to our monthly expenses. It's nice to say, well, maybe in a year when you guys decide what to do, we'll get the money back. But meanwhile, we're committed. First of all, the money up front for me was about $1,500, and then almost $150 a month on top of everything else. Yeah, maybe in a year or two we'll get it back, but it's still a burden.
It raises the price of rent. All of this raises the price of rent. I have talking to my Gen Z kids and they're like, we can't afford to live here. We can't ever buy a house. And they asked me why. And I said, well, pre-taxes are this, and we gotta pay for this, and the homeowner's insurance is this, and now we have to have fire insurance, and this is why. It's not your guys' fault alone, but this is why Gen Zers can't afford anything.
It's tough when we try to recruit people out of state because they can't afford to move in to work here. Understand.
I mean, a fair fee would be okay. I mean, a fair fee, I don't know what a fair fee is, but not $9,000. I mean, for a 300 square foot, tiny
Tiny
home
house.
and a 400 square tiny.
Yeah.
I mean, I think there should be a fee.
I mean,
Don't
of
get me
course,
wrong. I'm not here to just say, hey, let's cut the fee out. I think it's excessive.
You guys have to do paperwork and give our bill serve letters. I mean, it's not like nothing's done behind the scenes. I get fees, but it was just excessive amount.
Perhaps the same fee that people who have an addition to their house pay, that add one more room.
Yeah.
If we could all address the board instead of other conversations going on. Thank you. Thank you for all your thoughts.
Listening.
This gentleman on the line want to talk?
Usually.
I have his written comment, but we have a 5 o'clock meeting also, so we are running short on time.
Well, I'm going to close the public comment portion.
Mr. Vayner, he can have his 3 minutes if he wants to talk.
Thank you for listening.
Are you saying I only have 3 minutes?
Thank you for coming.
Thank you.
Please go ahead, sir.
Am I limited to 3 minutes? Can you
Daniel did ours.
explain, please?
Can't hear you.
Can you hear me?
Yes.
Okay. So am I limited to 3 minutes of public input?
They have a 5 o'clock meeting, Rick.
Oh dear. Okay, I'll try to be quick. First, I want to briefly address your contention about the 2020 technical assistance letter. It did not merely address the proportionality, it addressed the threshold question of whether a connection fee or capacity fee may be imposed at all. It says ADUs for which no separate connection may be required and no connection fee or capacity may be charged. That is in the technical assistance letter. Second, HCD also warned the OVSD that the regulations, the district regulations and current fee structure are not legally sound. I think you guys get confused about that may word, and what they are saying. The important distinction is a property specific, no violation finding based on OVSD's representation of a direct connection is not the same as HCD approving OVSD to or approving capacity fees for ADUs that connect only to an existing private lateral. The word may in HCD's sentence must be read as a whole. HCD did not say OVSD may impose a capacity charge at its discretion. HCD said no separate connection may be required and no capacity fee or capacity charge may be imposed. The controlling word is no. And I can go on about that, but I want to also address the issue that somebody brought up about the possibly paying or getting a bill after they got their will serve letter. OVSD 82's own ordinance states 301.8 that capacity charges shall be paid in accordance with the charges effective on the date that a will serve letter is issued. You can't, after it is built and after a will serve letter, give somebody a significant and substantial invoice after you gave them a will serve letter saying in your own ordinance that these fees have to be paid before you get a will serve letter. And I can go on, but I guess I'm out of time. I wanted to speak about lots of other things, but I see that it is 5 o'clock and I will have to stop. I appreciate the time you
Sir.
gave.
Thank you, sir.
But what are the next steps for this? Does it go to the board? Or
Well,
another discussion?
that is closed, but that's a question we will resolve. She's right.
What we have to do is deliberate and give direction to staff as to what to do next.
As I said earlier, I think one thing we need to do is check the regulations as they were and we revised that ordinance in 2020, 2021. And just see. if
Because we
that
very
language-
explicitly changed the proportionality portion, and we very explicitly did not change the other.
I'm more concerned about the state regulation around and or cap charge and in what instance. So if the language that exists now, same language that existed back in 2020 and 2021 when we revised ours. The first question, has any of that state language changed? Even though the numbers may have changed, just so we have a history of what's gone on. As far as legislation or ordinances since that, not our ordinance, it's since then. And then it would seem, it's still not clear what really is, but if there was a way to know how many of these connections, how many times did we collect connection fees and what was the amount for each year from 2020 to 26, which I think is probably in here, but I'd have to look at it because I just need to know how much did OVS actually get over those years. And then a third thing is if there is any of a state agency or somebody, it's what the state policy is on retroactive. And we've retroactively changed, refunded in the past. There's a lot of pushback both from our attorney and members of the board, but we ended up doing that. So, we know we can do it voluntarily, but what's the requirement for it? You know what I mean? Versus just voluntarily doing what we may or may not think is the right thing at the time. But I would think.
Question of Candelaria is at what point between the date when you said our ordinance was okay, now when you say it's not okay, at what point did HCD's, I'll call it direction to us, as how to implement the ordinance, when did that change?
And then the fourth thing that I would suggest is given that we now have this letter from Candelaria, we need to do some, I'll call it temporary ordinance revision such that we can't keep charging that from today forward. Because we now know we're not supposed to. That I think we can do quickly without having to go back and resolve all the other issues around that retroactive stuff. And I assume we could do that, but I think to even we implement a ordinance change to handle point forward, that requires all the steps that Allison takes through and all that stuff. I don't know if we can simply do it by policy. I don't know, but that would be something that maybe you could help us on too. Just make the policy.
How about we recommend to the full board that we suspend the enforcement of 82 regard to indirect connections
Existing.
until we get more legal opinion.
I would support that.
We can do that for sure, I would think. I don't know what requirements that, because that's effectively a application to an ordinance. So I don't know what we
It is.
have to do to make that possible.
Again, our ordinance, it also doesn't directly direct it. So it's more about how we are applying the ordinance.
Well, that maybe can just be done with a policy statement decision. Anyway, those are the four things I would recommend we do. And then once we resolve all that, then we can come together and decide, okay, well, given all that, with knowledge about guidance around retroactivity, how far back do we go? That's probably going to be a $1 million discussion. It sounds like.
Do you feel like you've gotten enough to
I've gotten enough.
go away and bring your
Bring more
queries?
information back to the board, full board.
Is it legal for us to it's legal for us to recommend a course of action in terms of suspending enforcement of at least a portion of 82. But the board would still have to vote on that.
Sure.
Can that be agendized for Monday?
Not.
Not yet. Okay. Oh, I thought it was 72 hours.
We've amended the agenda. I don't know that we'll be able to, I think this is
I think it'd be better to
Yeah,
get more information.
very robust conversation. I don't know that this agenda can appropriately accommodate it, given its
Okay.
size.
Okay. Well, we have it in the minutes for this committee meeting. That we would like to, I think, that we would like to suspend enforcement of that portion of 82 until we get more information. But that's just our recommendation to the board whenever the board gets it. Okay. Any other business before the committee? Then at 5:08, the committee meeting is adjourned.